kind of as some of you know who have seen or heard me speak before, I'm kind of a wanderer when I talk. And, you know, I'm one of those, if you tie both my hands down, I can't give a speech. So, but I'll kind of wander around here this morning. I think we've got a nice-sized group here for this talk. I'll try to stay out of your way so you can see the screen. Also, you should have a hard copy of all the slides I'll go through, so you can follow along there if you'd like. And as I understand it, the presentation, both audio and the PowerPoint, will be available on the Iowa Pork Producer website. And thank goodness they're not doing video this year, right? So that way, people doing video get real nervous when you start walking all over the place, right? So again, appreciate you being here this morning. We'll kick off the Pork Congress with a talk about livestock environmental regulations and manure agreements. In getting ready to do this talk this year, which, as many of you know, we do this talk every year at Pork Congress, and as I was telling a few people here before we got started, as I was getting ready to do this talk, it occurred to me, and I'll say this very quietly, but it occurred to me, you know, these regulations haven't changed a whole lot over the last few years, and we'll just all go shh, because as soon as we say that, something will change. But because of that, I'm not going to go through the basics today of, you know, often in this talk I go through, okay, if you're going to put up a building, you're in this category, here's what you have to do. If you're this size category, here's what you have to do, etc. We've covered that in past years, and I'll touch on that. And if any of you have specific questions about something that I don't cover today, please, I'll be around afterwards. I'll be glad to visit with you. It's not my intention to leave anything out, but to get this done in an hour, you just can't cover all of that. What we talked about doing this year is maybe me not rushing through things quite so fast, we'll see, but covering some of the, what I would call high points, some would call them low points, of gray areas, DNR interpretations, the kind of things that, in my opinion, you aren't going to get from reading the regulations or looking at some of the publications that are out there. I'm going to try and tell you what I see in working with DNR, that they may look at it a little differently than maybe I do, and and others. And it's not my intention to pick on anyone except myself. But you just need to know about those things, because in a lot of my practice, my work for the Iowa Pork Producers Association and my work for individual producers involves getting a phone call that says, they're trying to do this, and wait a minute, I don't understand. How can they do that? What do the regulations say, or what don't they say, etc. So that's what I'm trying to cover today for probably the first half. And then we want to get into manure agreements. Now, manure agreements themselves are not DNR regulations. You're required, by manure agreement, I mean, you have the manure, you have the operation, and you need a place to put the manure, and it's not on your land. So you need an agreement. DNR does require an agreement. The Iowa law does. But what I see, and I'll cover this in a lot more detail, what I see, the DNR requirements, the Iowa law requirements for a manure agreement are very short, very brief. You don't need a whole lot to comply with DNR regulations. But, and not often do I say you need to go above and beyond the regulations, but here, in my opinion, you do, because you're building that operation with the reliance upon some place to put the manure. Or if you're the crop producer receiving that manure, which has kind of changed around here in the last few years, where we're seeing crop producers now really wanting that manure, and buildings are being built on people's land in places where they're being built there for the crop producers' pretty much sole purpose of getting that manure. And these agreements, if you only meet the DNR minimums, you could run into some legal troubles later on. And of course, that's where I and my kind come in, and quite honestly, you want to avoid me and my kind. And gosh, that's on tape, isn't it? So anyway, we'll go through that. And as always, when I give a presentation, I like to take questions as we go along. I think that's the time to talk about it. If you're comfortable with asking it, please raise your hand, and I'll try and repeat the question so everybody can hear. But if you're not comfortable with that, I'll be glad to answer questions individually afterwards. So with that, we'll take off. I said I wasn't going to cover the basics, but there's one basic we have to talk about, and that is animal capacity And this slide I've used many years. I'm not going to talk too much about animal weight capacity, but the foundation of all regulations with DNR is the animal capacity. It's not the number of hogs you run through that building in a year's time. It's the one-time capacity, and starting in 2002, for any new construction or expansion, we switched to animal unit capacity. What is an animal unit factor for swine? It's 0.4, more than 55 pounds, and 0.1 if they're 15 to 55. If that pig on site is never more than 15 pounds, there is no animal unit factor. That is the or the farrowing sites and the pigs that leave the site before they're 15 pounds. Now, let's just talk about this a minute, because a lot of the problems and troubles I see with DNR regulation and dealing with DNR is a basic misunderstanding of how this works. First of all, it's the maximum number of animals confined at any one time. Now, we can argue, ebbs and flows and this and that. The regulation and the law pretty much says maximum at any one time. It's the high water mark. So, if you often hear it's a 1,200 head building. Well, hold on a second. How many pigs really go in when you start out in a 1,200 head building? Often more than that, right? That's not a problem, but that is your capacity. If you put 1,300 head when they go in, your capacity is actually 1,300 head. Now, what the key is, if you're tight on whether you're bumping into a regulation that you need a manure management plan, or you need, at the 1,250 head, which is 500 animal units, or if you're bumping into if you tried to stay under that at 1,200 head, and then you put 1,300 in there in the beginning, have you violated your DNR requirements already and needed a manure management plan? No, because you get a 0.1 factor until that pig is at 55 pounds. So reading the law literally, if you did not get a manure management plan for your building, say building it as a 1,200 head building or something less than 1,250 head, and you put 1,300 head of pigs in there, you're okay until they get to 55 pounds. And reading the law literally, once those pigs reach 55 pounds, you better have less than 1,250 head in there. Pardon me. The reason I spent a little time on this, because I have given this talk quite a few times. I gave it last spring, and a producer came up to me afterwards, off to the side, and says, say that to me again. And so we went through it again. That producer's understanding was, as long as you were down to the 1,200 head or below the 1,250 by the time they went to market, he was okay. No. Technically, it's when they get up to that 0.4 factor of more than 55 pounds. Again, that's just something to keep in mind as you're stocking these buildings. Any question on the animal capacity? And again, it's the maximum number confined at any one time multiplied by the animal unit factor. Okay. Then we go to another area where I see a lot of questions are, do I have one operation or two? Should be pretty simple. In a lot of cases it is, but with producers putting up multiple buildings, and if your intent is to get that site far enough away to be considered a separate operation so we don't add the animal capacities together, which kicks you up another category, what you need to focus on is right down there. And I underlined it and it's on your hard copy underlined. If you want that new site to be a separate site for purposes of permits, manure management plans, etc., then you need to look at what is the animal unit capacity of both sites, what you already have and what you're proposing. Now, this assumes you have common ownership, that you own them both or you manage them both. Then you look at the distance, okay? And you look at the combined animal unit capacity, and if that's less than 1,000, then they have to be at least 1,250 feet apart to be considered separate. If you add those two together and it comes up to more than 1,000 animal units, they need to be at least 2,500 feet apart. Okay? If they're not, then they're one site, and you have to add them together to determine if you need a permit, etc. Seems fairly simple, but here's one of those gray areas. I don't think this is gray myself, but DNR disagrees with me, and they don't think it's gray. They think it's clear on their side. I think it's clear on the other side. But this is DNR's interpretation. I know I've talked about this a lot at past meetings, but I'm going to keep talking about it because it still comes up. You know, back here on this slide, I talked about if you have common ownership or management. What if you have two sites that are owned by two separate individuals, but they feed pigs for the same owner? They have the same contract feeding arrangement with the same company, owner, farrower, whatever you want to call it. Now, you and I would think those are two separate sites. There's not common ownership, and they each manage their own sites. Those producers both take care of their own pigs. They're separate. But the rule says common management is significant control of the day-to-day operations. And I believe that type of arrangement, the owner of the pigs does not have significant control over the day-to-day operations. DNR disagrees, and they call it common management if two producers contract feed hogs for the same owner, if the owner has the right to control marketing, feed, rations, or vet services. Now, folks, you can read the rules till you're blue in the face. Read every copy that's ever been written by DNR, the Iowa Environmental Protection Commission, and you won't see that. That's not in the rules. That's a DNR interpretation, but that's how they look at it. So if you've got those of you working with integrators and others putting up sites, you need to keep that in mind, that if you've got two sites where the same pig owned by the same company or person are in those sites, and they're closer than that adjacency distance, then you've got common management, and they would be considered one site and could get kicked up into the category needing a permit, etc. Okay? The question was, has that been tested? And no, it has not. The problem that comes up, I can be a smart aleck here as an attorney and say, boy, I wish somebody would test it. That's how I make my living, is testing things. But the short answer is no, it has not been tested, as in challenging DNR and going to court or going to an administrative law judge. What happens is, when you look at the cost of people like me to do that versus, okay, just move it a little further away, and time factor, it takes a good year to challenge something like that. Most producers look at just complying with it because it's easier than challenging it. And even after, I've had several situations where the buildings have been built and pigs are in them, when it's discovered, then the easier thing to do is just to change the arrangement, one producer feed for somebody else, change the structure somehow. So no, it has not been tested. I'm hoping someday, if we do have legislative changes, which I'm not asking for, but if we do, we can get this corrected, because I'm not sure DNR really thinks this is the correct way to do it. They just believe this is the way the rules are written. And in fact, for cattle and open feedlots, when a new legislation was written several years ago, specifically we covered this situation, and it does not apply to cattle open feedlots, but it does to confinement operations. Okay. Yes?
What about if there's that together?
The question, if I can paraphrase your question, is they were okay to start with, but then somebody later on decided to start feeding for the same owner, and so after they were built, they come together as common management. The answer to that is, I would say a literal interpretation of DNR's interpretation would mean they have a problem. DNR has said that they don't consider that to be a problem. Now, all right, I see a few smiles out there. I'm supposed to be the devious one, not you. But one might say, okay, we'll build it this way, and then a year or so later we'll do it this way. Now, if there's evidence that it was done intentionally, I'm going to stay out of that. I would never get into anything like that. But I think that, to me, this illustrates the problem with interpretations like this. If you have a situation where they interpret it this way, but they say later on, if you sell a site and they become common management, that doesn't apply then, to me that illustrates the problem with their interpretation in the first place, because that just invites, shall we say, creative business arrangements. So I think I answered your question, sort of, but I have a lot of problem with this interpretation. I have for years. DNR knows I have a lot of problems with it. But it's in place, and that is their interpretation. And again, as I answered your question, most producers have looked at it. It's a lot easier to just deal with it, figure out, comply with it, rather than challenge it. And I am hoping Someday we can address it legislatively so we don't have this gray area. Okay. Let's see. If you have confinements to open lots, and in the interest of time here, I may not cover this. We don't run into a lot with hogs. You can, of course, with a confinement building, and then somebody has the outdoor open lot finisher, the old Cargill outdoor unit or whatever. They put some overflow in, or may use it all the time. We run into that. We run into this more with cattle feedlots where they have the confinement deep bedded buildings, and they also have an open lot. But these adjacency distances, just let me say, I'll leave this slide to your reading. If you have questions about it, I'll be glad to visit with you. But the short answer is these distances I just talked about when you're looking at confinement to an open lot under the same ownership do not apply, because Iowa law says you don't count them together, confinements and open lots, but EPA, as I point out here, says you do. And what we get into here are NPDES permits with the Environmental Protection Agency versus Iowa DNR. And it gets a little complicated, but again, if you have a question, I'll be glad to talk to you afterwards about it. The key is if you're looking to a confinement and open lot, are they adjacent? I'd sit down and talk to somebody about it because you don't want to get into this NPDES regulation if you don't have to. Okay? I wanted to include that, so I at least brought it to your attention. Okay, here's my slide on the 3 categories of construction requirements. In a lot of the talks I've given, we spend maybe a half an hour on these. Today, this is it. Here's the 3 categories. The SAFOs, 500 or less, between 500 and 1,000 animal units where you need an MMP and a construction design statement. Again, if you want details on these requirements, let me know. I've got presentations that go into that amount of detail. I'm just not going to do it today. And then you have the 1,000 animal units and up. Those are the permitted sites. You need a construction permit and a matrix. This isn't a gray area. This is a surprise, pardon me, to many people. Often you'll see somebody will put up a 2,400 head building or site with the intention of adding later, which would kick you over the 1,000 animal units to need a permit. That's fine. Just remember, you have to wait 1 year under Iowa law. After you build the 2,400 head and have it completed, you have to wait 1 year before you can get a permit if you want to add a 12 or something like that. Comes as a surprise to some people. There's a 1 year waiting period from non-permitted construction to permitted. Have a couple of questions. Jay? That depends on who you talk to. I had a situation a year ago where DNR said, we're so busy. What'd you say? You're talking to me? All right, I'll answer it then. Did everyone hear the question? I'm not sure I repeated it. Sure, I'll be glad to. I usually try and do that, and I think I missed that. The question was, is the 1 year waiting period, one reason for repeating the question is so I can restate it so I can answer it too. But anyway, the 1 year waiting period, is it from, do you have to wait a whole year before you can apply for a permit, or is it waiting a year before you can get a permit? Because there's a 60 to 90 day, sometimes more, waiting period. That was the question. The answer in the rules, and as the law says, is it's a 1 year waiting period to get a permit. So you could go ahead and apply ahead of time. And I think that's the way DNR is interpreting that now. Ran into a situation a year ago where a producer, 6 months before the 1 year waiting period was up, went ahead and applied thinking, go ahead and get it done so I don't have to wait. And then I realized you can't issue it until the 1 year period is up. DNR sent it back and said, send this back to us when you're at the 1 year. Well, I worked with the producer on that, and what we agreed to, because DNR was swamped with permit applications and they didn't want this one taking up a spot, so to speak. They wanted to get the ones done that were ready to go. So what we worked out with DNR was at 90 days before the 1 year period was up, we sent the permit application in. So therefore, we were kind of within the time frame when they could issue it then. Okay? All right. Question. There's a question over here.
Yeah, my question was, so what is the 1 year calculated from?
Completion of construction to get a permit being issued.
Is there some magical thing?
Yeah, we are talking about the gray areas today. There is a definition of the rules of beginning construction. There is no definition on completion of construction. Okay, so here's where we get into us versus them. And clearly, the way I look at it is you can clearly say construction was completed when the pigs go in. Yeah, maybe sometimes pigs go in before it's completed, but our general goal is to have it completed when pigs go in. So that would be a bright line where clearly that would be completion of construction. If you're pushing the date further back, then you're going to have some verification from the contractor, somebody say it was completed on that date. I've not gotten into that situation myself. Maybe some of you have, where we've really had to argue, because generally it's not a big period of time. My experience is pigs are standing on the truck usually waiting to get into those buildings, and so that's completion of construction. But there is no definition in the rules. Any other questions on that? Okay. The matrix. I'm sure a lot of you have had experience with this. I'm not going to go through the details, other than I want to say I like exemptions, and there is an exemption. Don't forget this exemption. First of all, make sure your county has adopted it. January is the month every year where each county has to decide if they want to adopt the matrix for the next year. So double check with your county after February 1 to see if your county did adopt it. Generally, we have about 10 to 15 counties in the state that don't adopt it, but that has changed. Every year there's a little bit of difference there. Secondly, if you're expanding a site that was constructed as of April 1 of 2002, that's when the law went into effect, or that's the date the legislature picked, and after expansion you won't be at more than 1,666 animal units, which is the old permit threshold of around 4,200 head. If you will be below that after your expansion, then you don't need the matrix, even if you're in a county that requires it. And nothing gives me greater pleasure than to get a call from a producer who is worried about having to do the paperwork, etc. And they say, and then how do I do this matrix? And I say, are you expanding an existing site? Yes. Was it there as of April 1 of 2002? Yes. And I say, forget about it. You don't need it. And we both smile, because it just means forget about it. They gave you an exemption. Use it. All right. Supporting documentation, including design, operation, and maintenance plans. First of all, you have to make sure that supporting documentation is there. One of the trouble spots we've seen is some counties aren't real particular about some of this. Some are very particular. Some aren't. And DNR has taken the position that if it requires supporting documentation, and the county may go ahead and pass it, but if they see that the supporting documentation is there, DNR will say that you don't pass the matrix even though the county has passed it. Now, that's not what the law says, but their position is that that is not a complete permit application. If a county does not pass the matrix, then DNR independently scores the matrix, and they do go in and look at everything, including things that the county may have passed. So here's the way it works. You give it to the county, and the county, let's say they deny it. They say you don't have enough points, and they say it's because of questions 1, 2, and 3. The law says DNR independently scores that. DNR may say, all right, we'll give you number 3, but you don't get 1 and 2, but we also take away 4 and 5, because they go in and score it like it's a clean sheet of paper that the county never saw, and that's where some of these problems can come into place. So far, and I better be careful saying this, I'm on tape, but so far of every permit application matrix that has been denied by a county, I don't know that I've ever seen one yet where the DNR didn't deny something that the county had passed, etc. And ultimately, I think all of those I've seen that have been denied by a county have been denied by DNR also, but for different reasons sometimes, which means you have to start over. Okay? Just quickly on this slide, I'm jumping now away from the matrix. One further thing I'll say about the matrix. There's some points that, for instance, you get points for being formed manure storage. If you haven't submitted one lately, take a close look at what you submit for a design, operation, and maintenance plan, because DNR is now, and they've been doing it for several months, requiring more detail I mean, you get, 30 points for form storage, I believe. And for what do you need for a design, operation, and maintenance plan for form storage? You're just going to make sure it doesn't cave in, or a lot of us have been looking at that as you don't have to say a whole lot for maintenance of a form storage, a deep pit. DNR is now requiring more detail. They want to know, about checking for cracks, but more than that, they have, at least for some producers, have said you need to tell us how you're going to check that tile line that's around it to make sure there are no problems. And I'll be glad to visit with you individually about this. Be very careful, and maybe you have some experiences in DNR's particularity they want with those design, operation, and maintenance plans. The two areas I've seen, or three actually, are the form storage points, the covered points, I'm going to have the wet-dry feeders, and landscaping. Take a careful look at what DNR wants to see. Now, see, here's the problem again, or maybe it's not a problem. If the county passes it, then DNR never sees these. And so you can have one approved without that degree of detail that I just talked about if the county passes it. County says it's fine, okay, it passes. But if the county denies it, that's one of those DNR has stepped in and denied those points even though the county passed those points. So to save yourself some time, I'd take a look at the detail. And again, I'll be glad to get you some information what I've seen DNR requires there. Okay? Here we're on to another subject. Keep in mind that if you make changes later, even though you don't do any physical construction or alteration, if there's an increase in manure volume or a modification in the manner manure is stored, and you're over that 1,000 animal units, you're supposed to get a permit for that. And unless those increases or modifications are within the limits of your permit or determined insignificant by DNR. And DNR has said that double stocking wean pigs in a wean to finish barn is not a significant increase in manure volume. Okay? This is one that catches people where you're already built, you haven't done any construction, but you make some changes as in putting in more pigs. And lo and behold, DNR does a site review or something and it's determined you need a permit. All right, manure management plans. We've been on this program for quite a few years now, since 2003, I guess. We're all used to dealing with the short form and statement there are no changes, etc. The compliance fee, get to write a check every year to DNR. Keep in mind, the law says the owner of the pigs is required to pay that fee, not the contract feeder. The way DNR handles that is they just want a check. They don't care where it comes from. They just want a check. You figure out who pays it. All right. DNR is also using the tier system to score producers on compliance to determine how often they're going to come back and review your MMP. They generally do MMP reviews, about once every 4 years, I think is what they're doing, Mike, or 3, is it? Once every 3 years if you're in the top tier. If you have a paperwork problem, they'll say, all right, we'll lower you a tier, and they'll be back once every 2 years. If you have a real problem, have a violation or something that is what I would call substantial, they'll put you down in the lower tier and say we'll be back every year. Again, don't go looking in the rules for this tier system and what I just explained because it isn't there. This is a DNR policy, and it was, in fairness to DNR, it was their attempt in working with a group of producers as an input group to come up with a system to reward those who are doing a good job and therefore they don't feel they have to come back as often to inspect them. Now, I, being a little more cynical type person, see how it could be used a different way, but I won't say that. Okay? All right. Record keeping. Records are important. And when DNR does these reviews, they will look at how you've kept your records, and that could be one of those things that could factor into the tier system. Okay? Record keeping of commercial nitrogen and phosphorus. We've been doing this for several years now. I'll leave this primarily to your reading unless you have any questions, but the key is here you have to have this statement. The producer must obtain a statement from the farmer who owns, rents, or leases ground where you're putting manure, specifying the planned amount of commercial nitrogen and phosphorus fertilizer to be applied to each field. DNR has a form you use here. Quite a few are using these. I haven't heard of any real glitches with this. Has anybody had any problems with this system not having it as DNR asked for it? Yes. The question was, and not necessarily related to this form, but you're saying, The question is, when DNR is doing a review, do they check a commercial applicator's records? Yeah. Yes, I have had them do that and compare it to what the producer has actually put on. I have had them do it. I haven't seen it too often. Anyone else run into that? Okay. The answer was a little bit, but it's becoming more as time goes on. So yes, and I have a slide coming up here, I think, on manure applicator records, or maybe I already passed it. There it is. I jumped over it. Get records immediately or as soon as possible from your applicator. Ran into a situation with a producer a year or two ago that they applied and then the neighbors complained. DNR came out. Want to see your manure records. Neighbors said you applied. Well, we did, but the commercial applicator has them. And sometimes commercial applicators take what? When they're busy, it takes a couple weeks to get those records put together. And DNR sent them an NOV, a notice of violation, for not having their records when DNR came. Now, I'm not saying you're able to get those the next day all the time. I think DNR was being unreasonable there. And an NOV is doesn't carry any penalty with it or anything, but it goes in the file as a violation. So get those records as soon as possible. Now, back to your question again. They will double check those records. So make sure that the applicator puts on the right amount and make sure those records are correct. Okay? I've covered those statements. Again, I realize I'm not going into a lot of detail on some things here. It's already a little past halfway of time, and I do want to talk about the manure agreements, but we'll get it all done. Here's the big thing on manure management plans and the phosphorus index. When it was adopted in 2002, it was adopted with a 3-phase phase-in as to who had to do them. We started with, the first time anybody had to do them was on or after October 25th of 2004. Any new operation then had to have the phosphorus index with it. And then the next step was after August 25th of 2006, operations that had submitted their first MMP, their original MMP, after April 1 of 2002 and before October 25th of 2004, they then had to do an update with the phosphorus index. And I'm sure some of you have been through that. All right, we're down to round 3. Now, starting August 25th of this year, with your first annual update after August 25th of 2008, the easiest way to say this is if you have a manure management plan and you don't have a phosphorus index yet, you need one starting with your first update after August 25th, which would be the September 1 update of 2008. And I think we're going to have a bunch of those. Those of you out there working on MMPs, are you seeing people getting ready for that, or are we expecting a big crunch coming? I think DNR's records show we're going to see the largest number here of any. I know there's been a lot of construction since then, but if it was after October 25th of 2004, they had to have it at the time they applied. These are the existing operations, the older ones before April 1 of 2002. They have to have it starting this fall. There's no leeway on time there to get your soil testing done, etc. So the message that needs to be getting out is you need to have your soil testing done ahead of time. If your annual update is due September 1, if it's due October 1, you got a problem there because it's hard to soil test before then, unless you like wading through standing corn or beans. So they ought to be soil testing this spring if they don't have soil tests that meet the DNR requirements. Okay? For those of you that work in this area, and I see a few of you out there, anything to add on planning for this? Again, soil testing to me is the big key. Get that done so you can get the phosphorus index prepared. The phosphorus index, in my experience, is not usually a big impediment to doing in your operation, depending on the type of soils you have, the topography, how steep is it, etc. But it hasn't been, I think it's a good tool. I think people are using it. I think it's helping people manage, phosphorus and erosion, etc. But by and large, it's been a paperwork headache, and that can be the hang-up here. Is that everyone else's experience? It's just getting it done, get the soil test done so you can get the phosphorus index in on time with your annual update. Okay? So an important date coming. DNR is supposed to send an advance notice that you need to have the phosphorus index done by this date. Have some of those went out already? I don't Have you gotten any, Mike?
Yeah. Some guys will never get
Yeah.
them. Some guys do.
Right. Sometimes DNR records don't get them out to people, and technically you're required to comply with the law whether you got the notice or not. Okay? Manure application, this is my standard slide here, not a gray area. It's just one as I drive around and look around the country this time of year, you see some manure going out. It's easy to spot this time of year. I'm not talking manure from a confinement operation necessarily. I'm talking an open feedlot, a small number of cattle, hogs, sheep. I don't care, whatever it is. And people, you hit a spell where you can get some of that out. When it's thawed enough, you can get the manure out, but it's still frozen. There's no law against applying manure on frozen ground, but you have to stay at least 200 feet away from a designated area, and creeks are a designated area. And this applies to any size livestock operation. I don't care. I've said it before, whether it's 2 horses or 2,000 pigs, this applies. And mainly we see it with some of the cattle operations where they haul manure out and don't watch that 200 feet distance, and DNR either sees it or a neighbor complains. So keep an eye on that, please. Liquid manure from confinement operations, again, the 750-foot distance to a residence doesn't apply if it's a SAFO. I'll leave that to your reading, the small operations. But again, the note, if you're injecting and turning on the ends, of course, and you have some spillage, dribbling, whatever you want to call it, and that's within 750 feet of a neighbor's house, that's DNR considers that surface application, and that can be a violation. So if you're injecting within 750 feet of somebody's house, keep an eye on that. And if you have some spillage, just get it worked in on the within 24 hours of the application. Or is that the same day? I always get those two mixed up. That's 24 hours on that one. The 200 feet to a creek is on the same day. Anyway, get it worked in so you don't have this issue. Yes?
I've always wondered what they define 24 hours to be. Is that from when I got done or from when I started?
The question was, when do they define the 24 hours? Is it from when I started, got done, etc.? Technically, it's supposed to be 24 hours from when that manure was placed within 750 feet of somebody's house. Okay? Now, you do what you can to help yourself out here. And I had a case where DNR cited somebody for a violation on this, and we were able to show that they did get it worked in within 24 hours, and we didn't have to have detailed time records or anything. We just had, the employee said, wait a minute, I worked that in. I remember it was before lunch, before I went into town for dinner. I had it all worked in, and DNR rescinded the violation. Okay? Did I see another hand? Yes? The question, the point the gentleman is making is at the Manure Applicator Certification meeting, you were told if you're applying at 10 o'clock, it has to be done by midnight. I believe, sir, what they're talking about there is the 200 feet to a creek. We have 2 different time periods here. The one to the residence is within 24 hours. The one, if you're surface applying manure within 200 feet of a creek or a well, any of those designated areas I had there, that has to be worked in on the same day, and that would be by midnight. Okay? So I believe that's what they should have been saying, or else, I'm positive I'm right on this. And it used to be within 24 hours for the creeks also, and then the legislature in 2002 changed that to the same day. So that would be by midnight. The residence is within 24 hours. Okay? All right. Stockpiling, this would be the hoop buildings, etc. Confinement operations, stockpiling manure. If any of you have hoop buildings out there and you're operating them as confinement buildings, that is, the pigs don't get outside, you must, and DNR takes a position that you cannot stockpile that manure, like just push it outside and then haul it when you get a chance. They say you cannot do that, the manure and the bedding, unless you put it in a structure that's pretty much the same as a manure storage structure. So, and that applies to any size operation, no matter how small, no matter how large. I just want to point that out if you're running hoop buildings out there. Yes. The question was all species? Yes, all species, all sizes, any manure that you can stockpile. There will be some discussion of that, about changing that, because there's a lot of concern from the turkey growers, the poultry operations, as well as the cattle, deep-bedded buildings, about having to, this is dry manure. It shouldn't be going anywhere. It's a lot of corn stalks, etc. Why can't it be stockpiled for a short period of time and taken out to the field and stockpiled? The only exception to that is if any of you know usually poultry operations that operate under Chapter 200A of the Iowa Department of Ag, and I won't go into detail there. They can do some stockpiling, but under DNR rules you can't. Okay, manure applicator certification. Here's one. I wasn't going to put this in, but it's one of those gray areas or gotchas. This may be changed this year. If you are, we have commercial applicator certification, we have producer certification. And you folks that do that know a lot more about that process than I do. But here's a DNR interpretation. If you as a producer are putting your manure on somebody else's land, under one of these manure agreements I'm going to talk about here in a minute, if you're doing that and you receive any money in return, if you receive money from the landowner for the value of the manure, if you receive it for the cost of putting it on, any cash comes from the landowner back to you related to that manure application. DNR takes the position that you are a commercial applicator, not a confinement site applicator. And the differences are in how many hours of training you need, etc. I do not agree with this interpretation. I don't think the law supports it. But this is how the position DNR is taking, so I just wanted to mention that. Question?
Who owns the manure in a contract?
The question was, who owns the manure in a contract situation? The lawyer answer to that is, that's however you write the contract. But usually the producer owns the manure. And so if it's my building, I own the manure, I own the pigs, etc., and I'm putting it on your land, then it's my manure, and I'm putting it on there. Once it's on there, it's your manure then. Now, some will try and write contracts, I understand, and will write contracts to say, you're buying it from me, you take it from me, it's yours, you come and get it. And that's what we often see in dry manure situations, where the landowner and others will come and get it and take ownership of it right away. Most of what I see in liquid manure is the producer owns it till it's put on. Go ahead.
What if, okay, you own the pigs, I own the building, he owns the land. I get that he doesn't own the manure while it's in the building.
Right.
In your building, and it came from my pigs. So
Yeah.
between us, who owns it?
I own the pigs, you own the buildings.
Yeah.
Usually the way DNR looks at it is, it's yours.
Because it's in my building.
It's in your building. Now, that said, DNR is not above saying to me that I have some responsibility that you do it right also. How's that for a lawyer answer? I think the best answer is depends. But no. And that'll cost you. No. It does, these three-way deals, four-way deals, two-way deals, whatever, it gets a little complicated. Nobody really cares who owns it until something goes wrong. And then everybody says, it's yours. It's not mine. And DNR says, we don't care whose you say it is. There's a problem that happened and we need to address it. But anyway, yeah. You all get thrown in the soup and you got to fight your way out. Okay, the applicator certification, composting mortalities. This is one of the items I wanted to put on the list as covering in detail here. And I have a lot of detail in your slides about the distances. How many are composting mortalities? Okay. Any problems you've had so far? No, you're saying, and be quiet. Move on. Here, just a couple of points I want to make and the problems I've seen. I'll leave to your reading these distance requirements and all that. I've just pretty much repeated DNR rules here as to what you need to do. And I want to go, here's a point I wanted to make. You have to design it for the third bullet point here, design it for the average annual death loss, so make sure you have enough room there. You can transport them from site to site. And I think I've got that. That's one of the points I want to make. Where do I cover that? Maybe I've... Was it back here? I'm sorry, I'm searching around here a little bit. There it is. Third bullet point down on this slide. Mortalities may be composted off-site at another livestock operation without a permit. I'm talking about a composting permit here. I should have had more detail there. I'm not talking about a construction permit. There are composting permits that are required. You don't need a composting permit to do this. There's no restriction on distance, and you do not have to be from the same owner or operator for those pigs. If you want to underline that, go ahead, because some DNR people do not agree with me when I say that. But it's in the rules, and it's clear, and we made sure it was in the rules. Now, there are biosecurity concerns, so I don't know how much of this goes on. But you can take pigs, for sure, if you own 2 sites and you only want to have a composting bin at one site, you can move them from one site to another. That was changed here just a few years ago. It used to be you had to get a variance to do that. You can clearly do that now. I believe, and the rules are clear, that you can also take your pigs to a neighbor and have the neighbor compost them, even though you don't own the site. You can do that, all right? So if there's any question about that, let me know. Transportation vehicles. I often get the question, do I have to have a permit for the transportation vehicle? No, you do not. Put them in the back of the pickup, whatever. Use some common sense. I often say, it says here, they have to be constructed to prevent release of mortality-contaminated materials. We won't go into what we're talking about there. Use the most direct haul route that avoids biosecurity risks. This isn't a biosecurity risk, but as a matter of public relations, don't go to town and go through the Burger King drive-up, again, you can haul them. And the rules specifically allow that. That's happened. Okay. Can you imagine the Burger King? All right. Let's see. Okay, last point there on that slide, DNR policy. If mortalities are composted in manure, the compost pile must also meet manure storage structure requirements. Of course, with liquid confinement hog operations, we don't deal with this, but I deal with this quite a bit with poultry, turkey litter, etc. They often will compost the dead birds in the manure, just bring out some of the dry manure to do that. DNR takes the position that if you do that, that compost bin also has to meet a manure storage structure requirement in addition to the composting requirements. So if hoop buildings, if you're doing some composting of mortalities in the bedding out of the hoop building, keep an eye on that. Manure agreements, we're there, and it's 20 after. Okay, I'll go ahead and cover as much as we can here, and again, I'll be glad to take questions afterwards. Okay, how many have an agreement or work on agreements between a producer and another landowner to take the manure? Okay? So, again, I think we're seeing more and more of these. If you're putting your manure on your own land or land that you rent, and I'm stretching a little bit there, but land you own, obviously none of this applies. If you're putting it on land you rent for crop production and it's your manure, DNR says you do not need a manure agreement. Okay? You don't have to show them one. Legally, do I think you need one to put it on there? Probably not, because you have a lease. Assuming you have a written lease, right? Even if you don't, if you have a verbal lease, putting manure on, 9 times out of 10 you're going to be fine. We've run into a few situations where landlords get upset about absentee landowners find out manure's going on there, and all of a sudden they say, oh my gosh, I'm opposed to hog operations and all that. You might, it's up to you. You just keep quiet in a verbal lease and keep doing it, or if you want to bring it to a head and specifically state in a written lease that you will be applying manure. We used to have to worry about all this, but last 10 years we've seen a lot of changes. The point I have here on the slide is the tenant. Can a tenant sign the manure agreement for purposes of a DNR manure management plan? No. Iowa law does not allow the DNR to accept a manure agreement required by the manure management plan that is signed by the tenant. It has to be signed by the landowner. That's in Iowa law. Open feedlot legislation a few years ago allows a tenant to sign one for an open feedlot. There was a bill proposed 2 years ago to allow, for confinement operations, to allow the tenant to sign the manure agreement. It passed both houses of the legislature, and the governor vetoed it because of opposition from certain opposition groups. So the law says, and DNR will not accept it unless the landowner signs. So that means you have to find these absentee landowners and have them sign the manure agreement. Now, if you don't have a manure management plan, as I have in that last bullet point there, then the tenant may sign. If you don't have an MMP, then you're just under general property law, and general property law says a tenant can sign, but they can't bind the landowner beyond the term of the lease. I won't go into a lot of detail there. What should be in these manure agreements? Who is responsible for manure application? Who pays for manure application? What I often see, and you tell me if I'm wrong, but what I see, nobody calls me and says, hey, Eldon, everything's working fine, take a look at this and send me a bill. I only get to see the ones where there's a problem. And I get the calls where things aren't going well and they say, take a look at this. And what I often see are the one-page manure easement that says, you know, the therefores and whereases and heretofores say, producer has an easement to put manure on landowner's land and has access, etc. And it's a one-pager, usually. All right, that's fine. Everybody, you know, again, nobody calls me and says, write me a nice long agreement. Everybody wants it short. And I, contrary to what people think, most attorneys don't charge by the word. But short sometimes is not good. In that situation where it just says, I have an easement to put manure on somebody else's land, it doesn't tell us a whole lot about who pays for it. It doesn't say anything. Well, if it doesn't say anything, then my response usually is nobody pays for anything, so livestock producer doesn't get any reimbursement for the manure application or anything. You have the right as a livestock producer to put it on there. You have an access easement. You can do that. The other thing, I mean, it doesn't cover any of these details, and aren't those details that we would sometimes want covered. So the short ones are okay. Often it's filled in by verbal agreements, which is all right until there's a problem. What usually happens is, what I've seen in the last few years, as fertilizer prices have gone up, livestock producers have said, wait a minute, I'm not getting paid for this. I want to get paid, and I've got another neighbor over here who will pay me for it, and I'm not going to put any more on your land because unless you pay for it. Landowner pulls it out and it says, well, it says I don't have to pay for it. But what else might it not say? I think I've got it. I want to go to this. Right here. What else doesn't it say? It probably doesn't say that there's any minimum amount of manure to be applied either. It's just an access easement. So I can have access if I want it, but I'm not required to. So the landowner then says, hey, wait a minute. They quit giving me manure, and now they're applying it on the neighbor's land. Don't they have to give it to me? Well, let's look at that one-page easement. That one-page easement, you look at it all over, and it doesn't say they have to give you anything. They just have access to the property. That is probably the number one complaint or dispute I'm seeing right now is landowners want manure, and they want it in a certain amount, and the livestock producer is not getting paid for it under that one-page agreement, and you see all sorts of conflict there. And I realize, you know, I have a lot of slides here on this, but if I can leave you with anything today, that's it. Get some detail in these agreements about who's going to pay for what, and is there a minimum amount of manure required. If the landowner, we see a lot of situations now where the landowner is selling off a chunk of land for someone to put up a building, and there's pretty much their sole reason to do that is to get the manure. That agreement should be very detailed that landowner will get that manure as long as the life of the agreement, the building is there. Otherwise, they wouldn't have put the building up. That is not the place for one of these short agreements that does not cover these details. Okay? I guess, again, that's the big thing that I see, and it used to be in the work I do anyway, I'd write these agreements or help the producer with it, etc., and then you wouldn't hear much more about them. But now I'm seeing more and more disputes, and there's a case in court right now where, and it'll go to trial sometime this summer, where the livestock producer wrote a manure agreement that specifically says landowner will get so many thousand gallons of manure per acre per year, and then there's a dispute now because the site was moved. So the question is, does that manure agreement follow because the site, he couldn't build on the original site, had to find a different site, but submitted the same manure agreement to the DNR, and now the producer says, but I don't need your land anymore because I moved the site, but wait a minute, that manure agreement went to DNR, and that says that the landowner gets so many thousand gallons an acre, and that landowner wants it. You know, when we first started working on these in the early 90s, it was, who will take it? We just need a place to get rid of it so we can build this thing. Now, people want it, and you know, as a livestock producer, you're in a good situation for that manure, and there is, you folks working on this stuff out there know that there are agreements out there where they're being paid based on the nutrient value, etc. It's a valuable commodity. That just presents a lot of issues in the manure agreements we see out there. Any questions about manure agreements? I have some time to cover a few more things here, and I've given you the slides that you can take a look at. I guess before I do that, one thing I want to mention, the Iowa Farm Bureau, the Iowa Pork Producers Association, right now we're working, if any of you remember the Livestock Regulations Handbook, we did one in 96, the 3-ring binder. We updated again, I think in 99, somewhere in there. And we're working on updating it again and should have that update out this winter, and it'll be on the internet. We are not going to do a paper copy, mainly because we can revise it, etc. And we're going to have a lot of detail on manure agreements, and we'll lay out a manure agreement, suggested clauses, and the problems with some of those clauses, etc. I've already talked about this. I think that slide is one worth circling. And here's another point I want to make under manure agreements, the second bullet point there. If you're getting an agreement from a landowner to put your manure on there, the first bullet point says record it with the county recorder, and then if that landowner sells, it goes with the land. And that's what you want as the livestock producer. Probably more importantly or appropriately, your lender wants that on there, and will make sure that it runs with the land so you have access to the land. What happens? We hope this never happens, but it does. What if the landowner has financial problems and is foreclosed on, and the landowner's mortgage holder forecloses on that mortgage? What do we attorneys do who represent, I don't represent banks, but anyway, what do attorneys do who represent banks when there's a foreclosure? When they step in, they want clear title to that land. So they look at the abstract, and then they file a lawsuit in district court that anybody who has a recorded interest in that land, they list as a defendant, and they wipe you out. They want you gone so they have clear title to that land, and that wipes out your manure agreement. Okay, unless you want to step forward as the holder of the manure agreement and buy the land, pay the mortgage off, and not many want to do that. What I advise people to do, and others, is get a non-disturbance agreement from that mortgage holder at the time you enter into that manure agreement with your neighbor. Go to whoever, say to the neighbor, and more importantly, check, have a title opinion done, and see who holds the mortgage. And then say to the landowner who wants to grant you the manure agreement, say to them, okay, but here's something I want your bank to sign to say that, and non-disturbance means if they foreclose, they'll leave you alone and you can stay there with your manure agreement. Now, some say, do banks ever sign that? Yes, they do, because they see the value in the manure being applied to that land. If you don't have that, and there's a foreclosure, you're going to get wiped out. Now, what often happens, by wiped out, I mean you lose your manure agreement. What often happens is, because the bank wants to clear title, and I say you will, there are always exceptions, but the bank wants to clear title, but when they resell it through the foreclosure or whatever, you may be able to come back in and get your manure agreement because people want it, but you're in limbo there for a while, or you may lose it entirely. Okay, it's now 10:30. I think I have covered everything we've talked about here. Or, I'm sorry, covered everything I had on the list of your slides. Always have something in there addressing liability. And with that, appreciate it. Oh, we have a question? Okay, the question is regarding hauling manure further now, which we are, and those that we have people who just haul it and don't apply it. Okay, what is their status under DNR regulations? No, they are transporting manure, and DNR looks at that as being someone involved in the application process and would need to be certified. As a commercial, if they're doing it for a business, they would need to be a commercial applicator license. Okay, if they do it, okay, if they're doing it as the employee of a farmer, then and they're not doing it as a business, and who's applying it once they get it there? Somebody else? Okay, then I think you're fine as being a confinement site applicator certification. I think we're okay there. All right. You know what the safe answer is? Be certified commercially. That's the safe answer. But I think if you've got producer on this end and producer on this end applying it, and then I think there it shouldn't be, and that person doesn't go do that for other people, it's producer's employee doing it, then that should be confinement site. Yes?
Along with that, for example, certification, you've got a CDL.
I'd get him certified for sure. And in your situation where it's your manure going to your land and you're applying it, then as a confinement site applicator, you should be fine. But yeah, for sure, get them certified. If they're hauling that manure out on the road, get them certified because I think you'll get. There are all sorts of arguments you can make on these things after the fact. Before the fact, take the safe approach and get them certified. If it happens after the fact, and my kind make our living making arguments, but you pay my kind for doing that, so just get them certified. I think transporting manure should be certified. Okay? Yes?
Well, they're saying, transporting manure was in the other site, you're going to use a drag hose. Are you allowed to use any type of containers there? So the drag hose can suck out of that?
Yeah, the question is, you're hauling to another site to temporary storage just for the drag hose to use, like a bin, so to speak. Yeah, you can do that. I know quite a few who do that, as long as you're just putting it in there and immediately it gets pumped out. Yeah, that shouldn't be a problem under the regulations.
Okay, is manure considered a hazardous material to a licensed vehicle?
How about if I say it depends on who you ask? Manure is kind of like the definition of a weed. What's the definition of a weed? It's a plant out of place. Manure is kind of like that too. When it gets in a place where it isn't supposed to be and causes a problem, then it can get called all sorts of things. What DNR regulations and Iowa law, we've worked very hard to try and keep manure in its own category. As you have to report a release, but we got it out of the definition or the reporting requirements for hazardous material into its own category. Now it's the same reporting requirements, but again, the answer to that question is a little depends on what happens and where. There are though the EPA, and there's a bill at the EPA right now, or not a bill, a proposed rule to take manure out of the definition of hazardous material for reporting the air hazardous, those 100-pound ammonia reporting requirements that we got into a couple years ago. There's a proposed rule to get it out of there. In general, I would say most environmental regulators consider manure, if it causes a problem, to be a hazardous material, but there are a lot of specific regulations that define it differently and get it out of there. How's that for dancing around your question? Any other questions? I'll be glad to take them. I'll be around afterwards. Appreciate your attendance and enjoy the Port Congress.